The court maintains jurisdiction to modify custody orders until the children are no longer minors. And so that is something that, depending on the circumstances, a court will hear, and a court will certainly modify it when appropriate, when it's in the best interest of the children to change that custody order. Court will entertain a petition, an application to change custody when there's been a substantial change in circumstances. There are so many different examples, so many different reasons that qualify as a substantial change in circumstance. Perhaps the strongest one is when somebody's job changes such that they commute. Let's say you live out in the Hamptons and you always worked locally, and now you have a job in Manhattan where you're commuting 2 hours each way. Under those circumstances, you may not be able to see your children at 5 o'clock each day. That would be a substantial change in circumstance where a court would certainly consider modifying whatever agreement or order may have been in place. There are situations where a parent might seek to relocate following a custody determination. And by relocation, we don't mean from Roslyn to Manhasset or from Garden City to Rockville Center. Really what we're discussing is when you're moving significantly, when you're moving from Long Island up to Buffalo or even out of state. And when that happens, that's something that a court is going to look very carefully at. And quite frankly, in most situations, it's not something that a court is going to permit. They're going to be loath, they're going to be very hesitant to do that because they're going to look at what is the impact on the other parent? What is the impact on that parent's relationship with the children? They're going to look at what are the reasons for the relocation. Is it because you have a better job, but you had a job here? That's something that's looked at with a great deal of scrutiny, a relocation request. There are times that they've been granted. We've had some success when appropriate, but it's something that you really want to be careful about, and you really need to consult with your lawyer before you consider moving. Unfortunately, there are times where a parent will refuse to comply with custody orders, where they may not return the child when they were supposed to return, or the children. They may decide that they're taking vacations, notwithstanding the fact that it was the other party's time. When those things happen, ideally, you'll speak to an attorney and you'll be able to work it out without going to court. But that's something that a court will entertain, and a court certainly may penalize the party that's violated the agreement. They may ultimately change the terms to avoid that happening going forward. When parties are unable to come to a settlement regarding custody, a judge will make that ultimate decision. And in New York State, that judge is going to be either a family court judge or a judge of the New York State Supreme Court. If a party is not happy with that decision, if they don't agree with the outcome, you do have the right to appeal it to the appellate division. But the appellate division is generally going to be constrained by the facts as they were found by the underlying court. And so those are difficult cases to win on appeal. If you're in a situation where you believe that the judge has made the wrong decision, that's something that you really need to consult with competent, skilled divorce attorneys that do a lot of custody work. That's something that we do and something that we're very comfortable taking a look at for you.